When will the men convicted in the 16th December 2012 gang rape and murder case be hanged? What legal options do they still have to contest their death sentence? And what happens after all legal avenues are exhausted if their death sentences are upheld? Rumours have been rife for days now that the Nirbhaya convicts could be executed on 16th December, the 7-year anniversary of their heinous crime. Reports have pointed to requests for hangmen from Uttar Pradesh, for deliveries of ropes for the hanging from Bihar, as proof that the hangings will take place shortly. But could this really be true? Aren't there review petitions and mercy petitions currently being considered by the Supreme Court and the President? Here's Shreya Rastogi, a capital defense lawyer who works with NLU Delhi's Project 39A, the Centre on Death Penalty, explaining the pending legal challenges by the Nirbhaya convicts and why a rushed execution would be against the law.
Firstly, we must acknowledge that there are proceedings which are currently pending before the Patiala House Sessions Court, where the court is deciding whether a death warrant can be issued against the 4 accused or not. A death warrant is an order which sets out the time, place, and date of a person's execution. As per the law laid down by the Supreme Court, a death warrant cannot be issued until a prisoner sentenced to death has exercised all their judicial and administrative options. As per the news so far, the accused have many legal remedies which are currently pending. Firstly, one of the accused filed their review petition before the Supreme Court just yesterday. Also, all 4 accused are yet to file their curative petitions before the Supreme Court. Secondly, only one of the accused has filed a mercy petition which is currently pending before the President. The remaining 3 accused are yet to even file these mercy petitions. Since this is one of the final options that a person sentenced to death has, it assumes great importance, and therefore all accused must be given an opportunity to file their mercy petitions before the President, and they should be properly examined. Until these legal remedies are completely exhausted, the issuance of a death warrant against the 4 accused would be contrary to law.
The review petition filed by Akshay Kumar Singh, mentioned by Shreya earlier, has been listed for hearing by the Supreme Court on 17th December at 2 p.m, putting a 16th December execution a bit beyond the pale. Vinay Sharma's mercy petition still needs to be formally rejected by the President, even though the Law Ministry and the Delhi government have already recommended rejecting it. So, there are review petitions, curative petitions, and mercy petitions still to come before these convicts can be executed. Now, what exactly do these mercy petitions entail?
As per the decisions of the Supreme Court, prisoners sentenced to death have a right to have either their own lawyer draft their mercy, or if they cannot afford a lawyer, then a state-appointed legal aid lawyer should be given to them to help them prepare their mercy petition. This again shows the importance of filing a substantive mercy petition which sets out all of the arguments on behalf of the prisoners and makes a final pitch for why they should not be executed. Prisoners also have a right to challenge the rejection of the mercy petitions before the courts.
Once all these avenues are exhausted, it's still not as though the executions can be ordered immediately.
If a death warrant is issued, the procedure laid down by the Supreme Court also requires that enough time, with a minimum of 14 days, should be given between the issuance of the warrant and the execution of the prisoner. This is to allow the prisoner to challenge their impending execution and to have a final meeting with their family members and settle their worldly affairs.
It is understandable if some think this is dragging the process on too long. But there are reasons why there are all these checks and balances when it comes to the execution of a death sentence, in accordance with Article 21 of the Constitution, that the right to life can only be taken away by a procedure established by law.
Death penalty is a final and irreversible punishment. Therefore, utmost care and highest standards have to be followed before it is carried out. The process for imposing the death sentence therefore must be just and fair. Irrespective of how heinous or barbaric a crime may be, as per our constitution, all death row prisoners are entitled to these protections. Therefore, the rule of law in our country demands that procedural and substantive justice should be secured in each and every single case.